Hello, my name is Ridha Yasin. I did my presentation on 3 laws. First is the Anti-KickBack Statute, the second is the Stark Law, and the third is the False Claims Act. So, a basic overview. These laws are used to protect the integrity of federal program preventing fraud and abuse. So you guys are probably wondering, why were these laws created? To protect the public health, overutilization, underutilization, inappropriate provider, supplier, to decrease cost of care, to promote patient choice, to promote competition. Overutilization, what does that mean? The healthcare that was provided with a higher volume or cost than is appropriate. For example, this occurs when a drug or treatment is given without medical justification. It includes treating people with antibiotics for simple infections, or failing to follow effective options that cost less or cause fewer side effects. So what does underutilization mean? Underuse is when doctors or hospitals neglect to give patients medically necessary care or to follow proven healthcare practices, such as giving beta-blocking drugs to people who have heart attacks. Being a patient requires a certain level of trust. When a physician or other healthcare provider prescribes a drug, orders a test, or recommends a procedure, patients should be able to assume that they're receiving sound advice and quality care. At the very least, patients should be able to trust that the physician or hospital is acting in their best interest. Unfortunately, this isn't always the case. While most medical professionals put their patients first, there are some providers that are more concerned with their own financial gain. In today's economy, costs are increasing, reimbursements are decreasing, and although physicians are working harder, they're making less money. This is causing physicians to take extra measures in order to make up for the loss of income. To battle the money gap mentioned earlier, physicians is seeking ways to enhance income. One temptation is referral arrangements, whereby a physician is paid or pays another physician for patient referral. Examples of a medical referral is as obvious as a pharmaceutical company paying physicians to prescribe their drug, or as subtle as a hospital charging below market rent to a physician group in exchange for sending patients to the hospital. Call it a bribe or a kickback, the problem is the same. The Anti-KickBack Statute is a federal law that prohibits payments to induce referrals for items or services that are covered by federal healthcare programs, such as Medicaid and Medicare. What is anti-kickback statute? In some industries, it's acceptable to reward those who refer business to you. Let me give you a good example of anti-kickback statute. If a dermatologist pays for a telehealthcare equipment to be placed in their primary healthcare office, so they're hoping that this physician is going to refer patients to him or her. But this is considered a crime under the anti-kickback statute. Kickbacks are illegal because it can harm the federal healthcare program and beneficiaries. It can also lead the doctor into jail for many, many years, plus fines up to $50,000. Now let's talk about the physician self-referral statute, or also known as the Stark Law. It prohibits you from referring Medicare or Medicaid patients to designating healthcare services, to entities which you have a financial relationship. So what do I mean by financial relationship? It's covered by a law which include ownership, investment interests, and compensation relationship. This law applies to your financial relationship and also those of your immediate family members. So basically, I'm trying to explain that this law prohibits you from referring patients to your own practice, your clinical laboratory, your physical therapy, in where you have an investment or your family member owns this place and you're referring patients to this place to make money. That's against the law under the Stark Law. These are questions you ask yourself if you want to know if you violated the Stark Law. You say, is there a referral form or physician or designated health service? Then you say, yes, there is a referral. Then you ask yourself, does a physician or immediate family member have a financial relationship with the entity provided the service? If you say yes, then you finally ask yourself, does the financial relationship fit in a Stark Law exception? These are the exceptions with the Stark Law. First, to other physicians in the group for in-office services within prepaid healthcare plans, to entities in which the physician is invested, including publicly traded entities, rural providers, and a hospital itself, financial relationships such as rental of office space and equipment, personal service and arrangements, or a physician's recruitment. These are the exceptions that are allowed with the Stark Law. These are examples of the Stark Law violator. In 2014, Dakota, Florida's Hospital Medical Center was sued, and they had to pay $85 million to resolve allegations violated False Claims Act and Stark Law. They executed contracts with 6 medical oncologists that included incentive bonuses. They were also billed Medicare for certain tests and prescription drugs, and they paid 3 neurosurgeons more than fair market value. In exchange, they admitted patients that did not need to be hospitalized. So this is the difference between the Anti-KickBack statute and the Stark Law. So first, anti-kickback is for any item or service. Its intended must be proven knowingly and willingly. Penalties are criminal, civil, and execution from all federal programs such as Medicaid and Medicare. And exceptions are voluntary safe harbors. And then the Stark Law is referrals from physicians to designated health services, which include laboratory services, physical therapy, no intended standard for overpayment. Penalties are civil and executions from Medicare and Medicaid, and exceptions are mandatory exceptions. You could be protected from the anti-kickback statute by a safe harbor. And what that basically protects you is certain arrangements when an individual or entity agrees to refer a patient to another individual or entity for special services in return for certain things. The referral to refer the patient back at a certain time or under certain circumstances. For example, a primary healthcare physician and specialists to whom the primary care physician has entity for specialty made a referral may agree that when the referred patient reaches a particular stage of recovery, the primary care physician should resume treatment of the patient. The safe harbor does not protect arrangements involving parties that are split a global fee from a federal program. The safe harbor requires the referrals be clinically appropriate, then based on arbitrary dates and time frames. And this is how you can be protected against the anti-kickback statute. The last law I want to talk about is the False Claims Act. It provides a way for the government to recover money through a lawsuit when someone submits a false or fraudulent claim. So the federal government basically hires this individual called a whistleblower, and this person sues the company or the individual that's making false claims for payment from the government. Examples that may be false include claims where the service is not actually rendered to the patient. The service is provided but already provided under another claim, is upcoded, or if the service is not actually in the patient's medical records. Claims also may be false if they result from referrals violating the Anti-Kickback statute, the Stark Law, which I mentioned earlier. And if the False Claims Act goes through, the government makes money of $11,000 per claim, and the whistleblower makes 25% of the money that the government made for catching this person that made this false claim. I hope you guys learned a lot about the Anti-Kickback statute, the Stark Law, and the False Claims Act. Thank you for watching my presentation.